Okay, and our final speaker for today is Dr. Ellie Ciammaichella. She is a clinical assistant professor at the University of Nevada, Reno School of Medicine, and her CV is quite impressive. So if you get a chance to look at it, please do. But I'll give a few highlights. Excuse me, highlights. She has a Bachelor of Science in Chemistry and Chemical Engineering from UC Berkeley, a Juris Doctorate from the George Washington University Law School, and then her Doctor of Osteopathic Medicine from Touro University, Nevada College of Osteopathic Medicine. She also has a lot of experience with an internship, residency, fellowship, and previous to her medical career, a legal career. So quite impressed already, but I can't wait to hear what she has to say. She's going to talk about clinicians' liability for recommending cannabinoids.
Thank you for that introduction. I'll be discussing the clinician's liability for recommending cannabinoids. I'm based in Reno, Nevada. I have no conflicts of interest, and just as a reminder, this is not legal advice. The lecture does not create an attorney-client relationship. And I just wanted to share a little bit about myself before I start. I'm an avid recycler. And while at Cal, I was in the California Marching Band. And then while at Touro, Nevada, I was in the a cappella and joined the American College of Legal Medicine as a medical student and finished my physical medicine and rehabilitation residency in Houston. The learning objectives for today is to paint the legal landscape of medical cannabis therapy, MCT, describing how to minimize liability with recommending MCT, and then describing next steps to decrease the gray zone in recommending MCT. So first, what does the legal landscape currently look like? Well, let's ask a few questions. Who here thinks botanical cannabis is legal in the United States? So I have one for yes. How about no? Okay, so no, it is not legal based on the Controlled Substance Act. Botanical cannabis is a Schedule I substance having no currently accepted medical use and a high potential for abuse. So then, of course, the next question is, can MCT be prescribed? Anyone for yes? And how about no? That's correct. Same reasoning. The Controlled Substance Act does not give you prescriptive authority to prescribe MCT. So then what am I talking about? We see this kind of thing going on all over the internet. What it should be saying is where cannabis is permitted in the United States. And in the United States, the first state to permit MCT was California in 1996. And just recently, in 2023, Kentucky has also permitted marijuana use. That leaves 9 states who have continued to not permit marijuana use in any form. So the question is easy when you're in these white states. MCT is not permitted and it's not legal in the United States. Therefore, it remains not viable solution in those states. But how about in the colored states where federal and state law conflict? We've already talked about prescriptions. They are not legal. So what am I talking about? The title kind of gives it away. We're talking about recommendations. The Ninth Circuit in Conant versus Walters has specifically stated that recommendations of MCT are protected under the First Amendment, but prescriptions, on the other hand, are not protected by the First Amendment and therefore remain illegal under the Controlled Substance Act. So then the question is, what is a medical recommendation? And when does a medical recommendation rise to the level of a prescription? And in those non-9 states that allow some form of MCT and require certifications, when does a certification rise to the level of a prescription, which would then be illegal under the Controlled Substance Act? So I can start talking about all the different cases, all the different policies that really make the legal landscape a mess. But basically, this kind of sums it up. There's the not permissible black area, and then there's the permissible white area, and then there's a whole bunch of gray area. And this gray area really adds to the uncertainty and conflicting legal status of botanical cannabis within the United States, and has created a chilling effect on the physician's willingness to recommend MCT. However, December 2nd, 2022, the Medical Marijuana and Cannabinoid Research Expansion Act of 2022 was signed. And in it, it states, it shall not be a violation of the CSA for a state licensed physician to discuss the currently known potential harms and benefits of marijuana derivatives as a treatment with the patient with capacity or legal decision maker of the physician. So this really emphasizes a safety net for a state licensed physician to provide informed consent based on currently known information to when there's a bona fide physician-patient relationship. So this is what I showed before, kind of the legal landscape before the MMCREA. And this is after. You still have gray area, slightly smaller, and there's a little more white area. The black area definitely did not change. So does that mean that lawyers are now out of a job? I don't really think so, because there's still a lot of gray area there. But what's to note is that physicians did not become a physician to be put in jail. They really are probably risk averse and would like to stay in the white zone. So the next question is how to minimize liability of recommending MCT by staying in that white zone and trying to minimize entering into the gray zone. The first thing is, do not assume that compliance with state law shields you. And this is really based on the Supremacy Clause of the Constitution. If state law oversteps federal legislation, case law precedent, or federal policy, abiding by state law alone does not shield a clinician from administrative, criminal, or civil liability. Number 2, again, do not assume that compliance to state law shields you. This cannot be overemphasized enough. The balance of federal and state law is based on the US Constitution. Number 3, know your state law inside and out. So if the state law does not overstep its bounds permitted by federal law and policy, then compliance with state law prevents the DOJ from enforcing crimes under the Controlled Substance Act. And that's based on the Robacher-Blumenauer Amendment, which was first signed into law in 2014 and must be renewed frequently, with the most current renewal good through November 17th, 2023. Number 4, do not delegate. As the MMCRA has specifically shielded a state licensed physician, it deliberately leaves out other prescribers, such as physician assistants and nurse practitioners. That being said, states such as Massachusetts and Pennsylvania allow mid-levels to certify MCT. And again, this is a reminder that following state law is not sufficient to prevent violation of the Controlled Substance Act. So now, should you certify a qualifying medical condition? There are some states, like Connecticut, that have an explicit list of medical conditions that qualify for MCT certification. In those situations, the physician is not required to certify a qualifying medical condition. However, there are other states like California that have catch-all phrases that allow the physician to determine if the patient has any other chronic or persistent medical symptom that could benefit from MCT. If the physician were to use that catch-all phrase to certify MCT, they would also be certifying the qualifying medical condition. And that, in that case, that could go beyond currently known potential harms and benefits. So this could be in the gray zone. And many physicians would probably avoid this situation. Number 6, avoid dosage and frequency. So dosage and frequency are often included in prescriptions and can definitely tip the tipping point from recommendations to prescriptions. And specifically in the MMCREA, they are limited protection to currently known potential harms and benefits. So specific dosage and frequency would probably not be provided in the safety net in that act. States such as Massachusetts allow the certifying physician to certify a dosage such as 2.5 ounces, 10 ounces, or a different amount. So again, in those situations, you must be careful. And number 7, be cognizant of funding sources. So there are a lot of federal funding sources for medicine, such as the Indian Health Services, the VA, Medicare, TRICARE, Medicaid. So for example, let's talk about Medicare and Medicaid. When a physician bills Medicare or Medicaid, they must certify that they are in compliance with federal and state law pursuant to the False Claims Act. If in fact they make that certification and are not in compliance, they are in violation of the False Claims Act and could result in administrative and criminal penalties. And how about the VA? The VA has passed a policy called the VHA Directive 1315, which has recently been updated July 28, 2023, which is after the MMCREA was signed, and does not allow any VA physician to recommend or complete forms for marijuana programs. The only time a VA physician is permitted to discuss MCT is if the veteran specifically requests the information or if the veteran reports use of marijuana. So this really gives the veteran incentive to go outside of the VA. And my question is, does the MMCREA and the First Amendment trump the VHA directive? I would argue that it does. And then this also is part of the gray zone as well. Informed consent is key. The MMCREA specifically permits the discussion of currently known potential harms and benefits, which is a large part of informed consent. Proper informed consent is also a defense to civil liability, such as product liability and medical malpractice. And telemedicine for MCT is often in the gray zone. And this is because it often has a weak physician-patient relationship, especially if the sole purpose of the telemedicine consultation is for MCT certification. For this reason, the risk-averse physician should avoid telemedicine altogether. But if they do use telemedicine to certify MCT, I would recommend limiting consultation to states of medical licensure. Even though the MMCREA does not require this, it does show a stronger patient-physician relationship, and ensure that the situs of the patient during the consultation is where the state is in the state where the patient is also trying to obtain MCT certification. And finally, number 10 is really to be a physician. And what does that mean? Overall, to minimize the pitfalls of MCT certification within a divided United States, the following major recommendations hinge on the basic duties of the physician to provide appropriate medical care and to obtain informed consent in the confines of federal and state law. First, stay in the realm of medicine. For example, physicians should not assess whether the patient is a resident of the state. That's a legal decision. However, the physician can be expected to report any information if they have reason to believe that the patient is not a resident of the state. B, create a strong physician-patient relationship. This was highly discussed in Conant versus Walters, as well as specifically stated in the MMCREA. And this can be done by providing appropriate medical care. This includes a thorough medical evaluation, including relevant clinical history, a physical exam, and diagnosis. The physician-patient relationship is easier to establish if the physician had seen the patient in person at an earlier date, and or if the physician provided care to the patient previously for medical reasons beyond MCT certification. And C, providing ongoing oversight and monitoring of the treatment agreement, including reviewing effectiveness and ongoing need of the treatment, managing side effects of treatment, and reviewing the PDMP where available. Maintain accurate and complete medical documentation that outlines the medical evaluation, discussion supporting informed and shared decision-making, the medical recommendation, the treatment agreement, and the ongoing oversight of the treatment agreement. E, refrain from certifying for yourself or family members, and avoid conflicts of interest such as financial or other incentives from dispensary or cultivation centers. So, what are the next steps to decreasing the chilling effect of the gray zone? First, encourage discourse like we're doing today. B, support high quality research on the efficacy, side effects, and alternatives of MCT. And finally, improve legal clarity by continuing to advocate with our legislature to pass effective laws that support evidence-based medicine. And you can send any questions by email or LinkedIn. And I have these resources.